University of East London, which of course is our partner in Stratford, where we will shortly begin constructing a new building, and I understand that there are colleagues here from the University of East London, so in particular, welcome to you. During her period here, Patricia rose steadily through the ranks, lecturer, senior lecturer, reader, and now professor, for those promotions being awarded for the outstanding research that she was carrying out and publishing, particularly in the area of international refugee law. But of course, throughout that period, and particularly in the second half of her time so far here, she started to develop a very significant management role, becoming the head of the law school under our old system, where we had around 20 different schools, but actually far more than that, becoming the leader of the movement which eventually resulted in law being established as a separate school of the college alongside the other 4 major schools. And she argued tremendously persuasively for that, but in fact she didn't actually make the critical argument as far as I was concerned, which is that at UCL, when they attempted a reorganisation and didn't do what the lawyers wanted, the provost eventually ended up losing his job. And so it was ultimately clear to me that law wanted to be a separate school, law became a separate school. But since it did, Patricia has led it, I think, with tremendous energy and flair, and resulted in it having a surplus which is nearly as big as the business school and rapidly approaching that of the business school. So in today's world of financial matters, that's an important part, but also, of course, what is important is the excellence of the school that she leads in research and teaching. This week, of course, as many of you will know, is the week of Law on Trial, when the school puts on a whole series of events, and it is, of course, entirely appropriate that that event, that week-long event, should kick off with the inaugural lecture of the Executive Dean of the Law School, Patricia Chewett, and it's my very great pleasure to invite her to deliver that inaugural lecture.
It really is wonderful to see so many colleagues, friends, family, students here. Thank you very much for coming. It is hard to escape announcements of the failure of the European integration project. The Schengen Agreement may well collapse, and with it, the ambition of a borderless internal zone. These events, disturbing though they undoubtedly are, have assumed crisis-like proportions because they recall the national rivalries and obsolete economic structures characteristic of the old nation-state form, which the integration process was supposed firmly to lay to rest. Whilst Eurosceptics might bemoan the European Union and pro-European camp applaud it, both were united in the belief that the European Union was not merely a new beginning of political community, but a political invention in the true sense. Now, for many years I have written on the subject of European integration, and it is precisely the failure of the European Union to be something more than Europe, or to be exact, the failure of the European Union to be something more than the history of Europe, that I have sought in these writings to expose. And by the history of Europe, I speak of a series of momentous events which brought about the modern world and the system of nation-states. This was a complex and involved history, conventionally dated from the early 15th to the late 17th century. It is a period of relevance to the discipline of law, I would say perhaps more than to any other field of the humanities. For this period introduced a basic norm, a law from which all other laws derived their legitimacy. This basic norm was what the political theorist Carl Schmitt defined as a law of the earth. Put simply, the existence of political community and all civic rights and responsibilities derived from political community are predicated on a taking of territory, or working on territory, or an attachment to territory. Schmitt deploys the term land appropriation to depict the various ways of being with territory, but these ways of being cannot be exhausted in any simple depiction. The distinction between the basic law of the earth and the rules and regulations to which this one law gives rise is at the heart of legal theory, and is usually expressed in the distinction between the law as nomos, as opposed to norm, or the law as thesis, as opposed to legislation. The age of discovery, during which colonial powers acquired territories, not primarily through violent conquest, but through intensive exploration of the world and eventual settlement, is a compelling example of the operation of the law of the earth, and has been, for me, an important source for my deliberations on the European Union. Since writing on the European Union, I have always questioned its characterization as a unique legal and political form. And to appreciate why I have thought it important to interrogate this claim, you must understand that some of the most distinguished European theorists and constitutional lawyers have advanced the European Union as a true political invention. That is the clearest illustration of the proposition that in post-war political thought and practice, land appropriation has ceased to be a condition precedent of a sovereign order. Constitutional theorists in the main would have it that the European Union offers proof that positive legal norms alone, that is legislation, can confer upon a polity its constitutive force. Indeed, as I'm sure many of you will know, for many, the European Union can only be conceived as legislation, made from a series of international treaties, supranational institutions, and exemplary judgments of the Court of Justice of the European Union. In other words, a polity instantiated through the activities of legal and political elites and legal innovation. Specifically on the question of the presence of a nomos, of a law of the earth, the European Union has been described as a system constructed by law, in the sense of legislation, that uniquely exists beyond the sovereign state, one in which the nexus or trinity of territory, nation, and identity has been radically disrupted. I would go along with the dominant characterization of the European Union to this extent. It is not simply a continuation of the nation-state. I will concede that it is a new political beginning, though not a political invention. It is ambitiously post-national, seeking to decouple legal entitlement from territorial belonging. It has been defined in opposition to the nation-state and has developed a remarkable set of compositions in that effort, not least of which is the famed doctrine of direct effect, which enables individuals to rely on European law directly before national courts. What the European Union has decidedly not succeeded in doing, however, is to signal the end of the law of the earth, or even to significantly displace it. Just as the taking of territory marked the transition to the modern world, so too has the taking of territory marked the transition from the modern system of states to the postmodern global order, insofar as the European Union can be interpreted as an instance of the global. The achievement of the modern system of states was to bracket people within territorial borders. The achievement, partial at least, of the European Union was to undo the territorial partitions produced by the state system. What interests me is that both achievements were to be effected by a taking of territory, or working on territory, or an attachment to territory. What I'm intrigued to know is whether any new political beginning can ever commence in Europe in an overcoming of European history that is truly absent the law of the earth. And what I have tried to call attention to in my work is the need for scholarship, especially post-colonial legal scholarship, to which category much of my work has been assigned, to turn its scrutiny of techniques of governance beyond acknowledged post-colonial settings and vocations, and thereby away from the past to the very present unfolding of the European Union. So turning then to the work which I assume has played some part in my appointment to chair. First, from the example of the European Union, I have argued that discovery is a normative concept. By this I mean that intensive exploration of territorial spaces remains the principal mode according to which a political entity, whatever its specific compositions, will emerge. Drawing on sources relating to the development of the European Union, specifically its founding treaties and constitutional norms, I have challenged myself to provide plausible evidence of the fact of a land appropriation through discovery. I argue, therefore, that the taking or working of territory is the source of all that is the European Union, the basic rule from which other positive norms, the legislation of the Union, derive. Next, and from essentially the same sources, I try to reveal in operation, in the development of the European Union, an important technique of discovery, one which was used as a justification for land appropriation. This technique, or legal fiction, as it's sometimes referred to, is known as the doctrine of terra nullius, land belonging to no one. The fiction being essentially that a political entity deemed to have reached the limits of its economic and social efficacy is a figuratively empty space waiting to be filled. Finally, contrasting the position of refugees in Europe with that of the European citizen, I argue that the law of the earth is not only what gives legitimacy to the European Union as a legal and political entity, but is determinative of civic rights, of basic social and economic entitlements, and of rights of political participation. It is for this reason that I argue in the abstract that the question of how social rights are distributed between people is one that is foreclosed at the emergence of political community. Controversially, perhaps, and drawing to some extent on the work of Frans Fanon, particularly his insights in The Wretched of the Earth, I argue that whatever informal groupings we might construct for ourselves and others, a law of the earth can know only four fundamental categories. Absent a true political innovation, individuals are putatively discoverers, settlers, nomads, or natives, and are more or less included in the social fabric according to these hierarchically structured groupings. So in what remains of the lecture, I will take each of these three arguments in turn under the headings, which are not the published headings, they're headings: the law of the earth in the European Union, the empty spaces of Europe, and earthly citizenship. So first, the law of the earth in the European Union. The most primitive, and yet still most decisive means of fashioning a political community is to populate a space with people, symbols, monuments, goods, and so on. Very quickly, it will lose all but a trace of the condition it was in prior to the new population. And it is in that light that I have evaluated the Treaty of Rome, or to give it its original name, the treaty establishing the European Economic Community. The most famous clause in the Treaty of Rome is that which has become known as the Four Freedoms, which declares the free movement of persons, services, goods, and capital. My work has concentrated on in relation to this particular strand of the argument, has concentrated on the free movement of persons, which entails the freedom of movement of workers, the right of self-employed persons either to establish themselves in another state or to provide services, And since the Treaty on European Union in 1992, it includes the right of Union citizens to move and reside freely in the territories of member states.